The prosecution, for some unfathomable reason, would have you not look at it, the protective measures, in-court protection on a case-by-case basis, but would have carte blanche that we say amounts to a license to lie. Because those witnesses are concerned of two things in my respectful submission. One is they'll be found out and prosecuted. The other is, when the lie is broadcast, maybe we'll get a torrent of new information to the defense that will assist us in showing the court that they're lying. Your Honour, the defense has witnesses under the Victim and Witness Protection Scheme of the court. Why? I have also gone on record in Kenya talking about all parties cooperating with the OTP and the defense. I have political parties seeking to control which witnesses I can speak to, and that witnesses should only go through a particular individual. Your Honour, the main thing is, on every situation, the court has an imperative duty, which is to decide whether or not protective measures are necessary, or whether or not the interests of justice demand it going publicly. And that must be tailored on a case-by-case basis.
What is said and done in the Senate, regardless of the good faith of it, might even unwittingly create or generate a national mood or community mood even that may make it very difficult for witnesses to feel psychologically able to step up and testify. And here we're talking about the provisions of Article 68(1) that talks about measures to be taken for purposes of protecting the psychological well-being of witnesses. Question is, can even good faith debates made in Parliament in relation to an ongoing case have a chilling effect on witnesses to the extent that there may be ordinary people in society?
I would like to say three things in response to that point, Mr. President and Your Honours. The first one is that it is my view that the inverse is the position, that the senators and the members of the National Assembly represent their constituencies. And so what they say, they are not the trigger, they are the product of the feeling. And so when they say it is our feeling that the prosecution did not conduct investigations, and we need to stem the likelihood of other people being mistreated by the prosecutor, that is a reflection of the wishes of the population. The second issue, Mr. President and Your Honours, is that in the entirety, at least to the extent I've seen, the senators and the members of the National Assembly avoided discussing issues of witnesses. They only dealt with the issue, the principal issue. And so we would very much like that this court looks at it, that the senators and the members of the National Assembly made whatever decision they made as a matter of principle, not as a matter in respect to the witnesses in this case.
What the Senate and the National Assembly are, in so many words, telling witnesses and telling victims is that cooperation with the ICC or participating in the proceedings leaves you witnesses, leaves you victims on your own. On the one hand, there is talk about cooperation, but on the other, there is an environment that is being created within the country which makes it very, very hostile to go against what Senate and the National Assembly would want to push to become national legislation. That's the way I see it, that if those two moves eventually end up resulting in legislation and resulting in the withdrawal of Kenya from the ICC, then the message is very clear that you are by cooperating with the ICC, you are going against what we see as the law.